Good morning, everyone, and welcome to the last Savvy Seniors Living seminar for 2021. We have survived another year of craziness, and I just hope you're all doing well and everyone had a great Thanksgiving. We did. My daughter surprised us. It was really fun. And so today's topic is a very important one, and obviously you agree because there's a good amount of attendees today that want to learn from these three amazing, talented, and qualified local experts that are going to speak directly to this topic. And the topic is avoiding disaster. Proper planning can avoid disaster. And we're going to dig into some tax, legal, and financial issues today. But first of all, I want to give a big shout out, as always, to our wonderful sponsors, because without them, this could not continue. And as most of you know, we are in our 4.5 year. So we're in our fifth year. That's right. We started our 5th full year back in June, and we are planning a great lineup for 2022. And please take note, it will continue to be the first Wednesday of every month, but we're going to be back at the Lafayette Library in the community hall in person, which I'm just thrilled about. And we may be changing the venue location. We will see. But for now, for today, it is at the Lafayette Library. Again, the first Wednesday of every month, 10 a.m. And we can't wait to see all of your smiling faces in person. That's going to be great. So thank you to our sponsors, our platinum sponsors, our Care Patrol, which is placement services, Byron Park Senior Living, which has both independent and assisted living. We've got Merrill Lynch, the Morris Group, and the Dayna Wilson Real Estate Team. And then our silver sponsors are Efficiency Matters, which is organization and move management. We've got Mutual of Omaha Mortgage, which only does reverse mortgages. Carlton Senior Living, the Pleasant Hill Martinez location. We've got Avedikian Law, and we've got Matthew here as one of our speakers today. Arosa Care, which is in-home care and geriatric care management. And then Oakmont of Montecito, which is assisted living. So thank you again, wonderful, wonderful sponsors. And I think that does it for our kind of housekeeping today. So one more thing, actually, Q&A. If you bring your mouse down to the bottom black bar below, well, I see Matt and Mark at the bottom. There's a Q&A, and that's where you can type in your questions. So you can do that as we go, or you can wait till the end, and then we'll make sure we have a few moments to answer your questions, because here you've got today Jim Gebhardt, or James Gebhardt, who is a CFP wealth advisor. We've got Matthew Avedikian, who is a wonderful estate planning attorney, and we've got Mark Halverson, CPA, and these guys have a ton of information to share with you today. So without further ado, we are going to ask Jim to introduce himself, tell us a little bit about who he is, his organization, what he does, and his background, so we can get to know Jim a little bit better. Jim?
Sure. Dayna, thank you very much. And what a wonderful, I think, service you provide to the community to be able to bring resources to seniors on, the phase of life that they're in, with all the questions that come up. So as a certified financial planner, this is my 25th year as a licensed financial advisor. I spent the first 10 years with Merrill Lynch and Smith Barney, and then in 2005 opened the doors to Gebhardt Group. We're a full service wealth management firm here in Lafayette, and then we have an office up in Roseville where my business partner and the other half of our team are located. So we do financial planning, we do asset management, we do some insurance work, and we work with local families who generally are going through some transition in life. And those transitions often will cause questions. They'll cause concern over, what should we do? And generally there's an intersection sometimes with money and what, how do we navigate through this with our money and making smart decisions and all that good stuff. And so we really appreciate the opportunity, Dayna, to be a resource and be able to contribute here today. Thank you for having me.
Wow. And I know that you jumped through some hoops to be here today. So thank you very much. And I'm just curious, what inspired you to get into this field?
Well, that's a long story, but I will shorten it down. So my great passion as a kid was golf. I fell in love with the game of golf when I was 10. By the time I was 14, I grew up in Syracuse, New York. So it's a short golf season back there. And I really wanted to be a professional. I wanted to be a professional golfer. Oh. But my dad had just started his own business when I was 12, and we didn't have the money. We didn't have the money for lessons and equipment and travel and all those kinds of things. So when I was going off to college, I'm like, I gotta learn this money thing. I gotta figure out how you make dreams happen, whether you don't have enough money today or you want to work toward it and and gather it up to make those dreams happen. And so I sat with my dad's Merrill Lynch financial advisor, and he said, go plop yourself down in the community where you want to live and become a financial advisor. And so that's exactly what I did. I joined Merrill Lynch in 1996 in downtown Oakland. And it's been a passion of mine for 25 years now to, really help people with all those struggles that they have around what to do with money, because there's not a lot of training, right? There's not a lot of training that we get as students going through, high school and college on money matters. And we're thrown into the deep end of the pool and expected to figure this stuff out for ourselves. So we love working with clients and trying to help them solve those problems that are most important to them.
I love it. I love your story. Thank you. Sure. Matthew, who are you? Tell us about your business and what you do and how you do it, what you offer, and maybe what led you to have a passion for the law.
Sure. Well, good morning, everyone. And echoing Jim, thanks, Dayna, for having me here this morning. These are fun. I've listened into quite a few of these, and so I've also been the beneficiary of listening in on these events that you host. So thank you.
Wow.
Again, my name is Matthew Avedikian. I am an attorney in Walnut Creek. I'm part of a 3-attorney firm. We handle a few main areas of practice, all matters of trust and estates, whether that's planning, as we're going to be talking about today, or administrations, probates, helping people when there's been a death in the family, helping people navigate through that. Also elder law, that would be, again, helping people get through some of these challenging transitions, primarily helping those folks understand how to work through the various public benefit programs that might be available to kind of help supplement some of the planning that they've done in some of those other areas. So we help people work through that. And then we also have a family law practice. That's not something that I am part of, but that's what the other group in our firm deals with primarily is family law. And so about 7 years ago, my wife and I started a firm together, and she handles all the family law stuff. And when things get a little contested and whenever it goes into litigation, that's kind of more on her plate than it is mine. I get to do what I do, and I like what I do, which is more of the planning and kind of helping people get through these situations. And I've been doing this for about 15 years. You asked what kind of led me into this. Well, I cut my teeth doing other areas of law, business law, real estate, for various corporate clients. And, once we kind of had a family, we got on our own, we realized that it was much more fulfilling to just start working with regular folks, helping people get their affairs in order, get their plans in place, kind of help them through all of life's challenges. And so we were able to really touch on a lot of those areas. And, we have a lot of longstanding relationships with clients. And that's a real, I think, passion of ours. That's what kind of drives us, is that, the chance we have to kind of really be part of our clients' lives for years.
Oh, I love that. Thank you. Well, Mark, tell us who you are and what you do and and what you offer, your organization, and maybe a little bit about what guided you to become a lover of tax issues.
Well, the issues aren't what I love, but I love working with people through the issues that are out there and ever changing. And seems like we're on an upward slope as far as complexity in the tax arena. But so my name's Mark Halverson. I was born and raised in the East Bay, lived in Lafayette, Concord, Walnut Creek, currently live in Pleasant Hill. Went to Cal State Hayward, got my accounting degree, decided I needed to get a little more education. So I have an MBA in finance from BYU. I have 2 teenagers. One's just starting at DVC. The other's a junior at College Park High School. How did I end up here? It was probably programmed into me. My father started a firm back in the 60s. His dad actually worked for him for a bit. So my grandfather worked in the business. My uncle worked in the business. My mom and my aunt both were involved. And now we're to the 3rd generation. It's me and my brother are CPAs. I own the practice at this point. So I don't remember when I started because I used to clean the office when I was a young child, and worked all through college for my dad, and then did 3 years in the big world at one of the big 8 at the time. And our services are twofold. We do bookkeeping and payroll for businesses, mostly which are in the dental arena. So dental practices, accounting. And the other half of our practice is tax return work, whether it be personal, business, trusts. We do some gift tax returns and some estate tax returns. And so that rounds out our practice. About half of our practice is tax return work. We kind of pride ourselves, or I pride myself, working with people over a long period of time. A lot of my dad's clients are still clients, many of who, of course, are in retirement years. So we have a lot of experience working with older clients and trying to help them figure out how to navigate the tax issues of retirement. Hopefully we'll touch on some of those.
Oh, yeah.
One of my mantras is that everybody's unique and there is no one size fits all in my mind. So what we try to do is assess where people are at and what their options are. If possible, give them more options by doing strategic movements and so forth. And we'll talk about that, I think, today.
Awesome. Awesome. And, I do see some new names, I would say faces, but I see some new names that are attending today. So for those of you newbies, I see my groupies there, but for your newbies, I guess I should introduce myself. I sometimes and often fail to do that. I just think that I've done that before, but I'm Dayna Wilson, and I am a seniors real estate specialist with Keller Williams Realty. And I grew up in Moraga, and I've lived in Moraga and Lafayette and Pleasant Hill and Walnut Creek, and spent a lot of time hanging out with both sets of grandparents that were both within 25 minutes of each other. And I think that was my beginning of my love with helping and serving older people. And now I'm one of those older people. So I started out in corporate sales for 22 years, and then I was in securities, and was just really primarily focused on real estate investments, large shopping centers and office towers and multifamily apartment communities. And then the market tanked, and I dipped my toe into residential, and I found my passion. And from there, I realized, I don't need to be all things to all people, but I want to serve people and make a difference in people's lives. And I chose this particular boomers, zoomers, and savvy seniors group because I'm one of them. And I think sometimes they need just a little bit extra help. So we started this again 5 years ago. I want to keep this going. This is free educational information, and it really is primarily just to inform, engage, empower everyone that joins every month or comes every month to make the right decisions for themselves based on getting the real truth and the real facts, and not listening to maybe what your neighbor says or what you hear on a TV commercial. All right. So today's topic again, I thought was important because as a real estate professional, people ask me tax, legal, and financial questions every week. And even if I know the answer, I am not licensed to give them that information. And so naturally, when we get those questions, we either seek the legal counsel or other professionals to get that information, or we'll introduce them to those folks. So again, thank you for the 3 gentlemen that are here today. We're going to jump right in, and we're going to start talking about documentation issues. This is not a fun thing to talk about because, oh, we'll do that later, right? We'll do that later. But we're going to discuss this because this can create challenges for people when they're preparing to transfer property. And this is primarily, we're talking about transferring property, but just life in general as well. So Mark, I think we were going to kind of tee this up for you to start with this question, and then we'll kind of hand it off to Jim and Matthew.
Well, first, I wanted to just highlight some of the things that we have to determine first. One is, are we dealing with a primary residence or a rental property that we're planning on selling? The issues are different for each of those. Some of the issues could be, I've owned the home forever and I don't have good records of maybe what I bought it for or what I've put into it is for improvements. Those are all important when you're going to sell an asset, is figuring out the tax basis. And the tax basis, of course, is the purchase price plus improvements. Now with a rental, you have the opposite. You have depreciation. You have loss carry forwards. They call them passive losses that have accumulated. And all those things are going to play into whether there's a big tax implication when you sell it or not. And what I generally find is that most people think the tax is going to be bigger than it actually is. So before you sell something, it's good to figure out what to expect. And a lot of times I get the call after the fact, oh, I just sold something. What are the tax implications? Well, at that point, it's still good that they're bringing it up before they do their tax return, but timing is important on knowing what to expect and making sure that you don't reinvest that money too quickly before you've settled your taxes. So gathering all those documents, or at least trying to come up with estimates for what those numbers are going to be, is important when you're planning to sell something. The other issues could be, if you're going to get rid of a property, are you going to try to give it to a family member or not? Or are you just selling it to the marketplace? There's different things that you can do: installment sales, you can do gifting, or you can maybe think twice about giving it and leaving it to them in your estate instead. There might be reasons to hold on to that property, depending on why you're trying to sell it, or do something now versus later. So timing can be important. Obviously, the tax laws are ever changing, and so professional help is good to know if you're up to date. I still get questions about laws that have been gone for over 25 years. Yeah. People somehow remember them, and I can't even remember when it changed. It's been so long, but so those are issues. There's issues about reassessment. Property tax reassessments can really become a problem, and if there's time, we can talk about some examples of that. I think just trying to do things with a big picture viewpoint. How does a transfer of a property coordinate with other things that you have as far as assets, tax issues? Is there a way to mitigate the taxes because of other things we can accomplish at the same time if we time it right? So again, timing is important. And
okay. Wow. Well, there's a lot there that I'm sure we could, keep going on. Jim, anything about documentation regarding transfer of property?
So not so much in the way of transfer of property, which Mark hit on all those issues, and as he opened with, how everybody's situation is very unique. I couldn't agree more that when it comes to things like this, the moving parts in everybody's individual circumstance is very, very important. Not to go off of what your neighbor or your cousin or what you heard on television on this stuff. What we see quite a bit in our world is accounts that haven't been labeled in the name of the living trust. Or the big one for us is the beneficiaries on IRAs. We have two different new client circumstances where the husband passed away in 20. The daughter did the transfer to the mom for the inherited, or not the inherited, but the spousal IRA. Never did new beneficiaries on the mom's IRA. Mom passes away, and now, based on the custodian's rules, the money, the IRA is now going to be owned by the trust. And that, as I think Matthew and Mark would both agree, is you don't want IRAs owned by a trust due to the tax complications of all that. So we get really, super detailed and granular to make sure that those beneficiaries and those kinds of things are set up, because it makes it pretty messy. So from a documentation standpoint, certainly with the real estate, it's good to know how that's held, if it's held in your trust, or maybe you have an irrevocable trust for some reason. But in our world, what we see most often is issues where the brokerage account isn't properly in the name of the living trust, or the IRAs don't have the proper beneficiaries based on what the client wants.
Got it. Interesting. Okay, Matthew, what about you? What would be important to know from a legal standpoint?
Well, we do get involved with how the property in particular is titled. And, we're talking about trust. And I know we're going to, I think, dive into that a little bit more, but let's assume that there is a trust and, you did your job and the residence was put in the trust, and that's the property we're talking about, or whatever property it is. Sometimes we get the frantic calls from, Dayna selling the property, and come to find out when title is pulled that the property is not where we thought it was, because so much time has passed that there's been some changes. Perhaps there was a mortgage, they refinanced and pulled it out of the trust, and it's no longer in the trust. So often we're able to fix those sorts of things if everyone's still alive and doing well, but sometimes, it can create some real problems and some real disasters when you're expecting this sale to close and you come to find out, well, there's not a clean title here that we can transfer. There's not any way a buyer's going to get title insurance here. And so we're often fixing it after the fact, going to court. The point here is we don't want to be doing that. We want to be trying to always be mindful of these big assets, as Jim was talking about, be aware of kind of where they are, how they're titled, is everything set up? I think one of our adages is, dust this thing off every few years just to make sure there haven't been any significant changes. And if there have been, especially if you've lost a spouse or, there's been just enough passage of time, it's never a bad idea to just make sure, because, not everybody, I think we get so focused on selling the house that we just kind of assume and forget that everything over there is all taken care of. Well, sometimes it's not. So that's what I would say, just from our experience with what we see. Title really, it's really important.
Well, and I'm just going to ask, kind of, it's off the topic, but it's documentation. But how often should we look at our trusts?
I would say it depends. I mean, certainly if there's a big event in your life, a big change circumstance, that's the time to do it. But aside from that, if everything is just going kind of as we hope and expect, at least every few years, maybe every 3 to 5, but no more than that would be, that's about what I would expect to see. So, that's kind of the adage that we have, and I would think that that's appropriate.
When, Dayna, just to add to that,
Yeah.
when we're meeting with a new client, we're always asking for their tax return and their estate planning documents. And let me be impossible to misunderstand. I'm not licensed to give advice in either of those areas. But what we do with their estate documents is we read through them and we just simply bring to their attention, who do they have as their successor trustees, or if there's still kids involved, any kind of guardianships? Because quite often, those trustee situations have changed. Maybe somebody's at a stage of life where it's really no longer appropriate, or maybe they live halfway across the country or halfway around the world, and they're named as trustee to settle the estate. And that's one of the things that we like to bring up, Matthew, is just, looking at that for them and making them aware of just who those people are. Because often, probably more than half the time, the circumstances for who they have as trustee have changed.
That's a good point. Yeah, that's a good point. Well, Matthew, we probably all know this, but let's just be refreshed and ask the question, what is the difference between a will versus a trust? And do we need one or the other or both? And in life, and then based on properties, how about?
Yeah, well, that's one of the $1 million questions here. And I would never assume that we all know. I mean, I think, a lot of us have heard these terms, but it's always good to get the refresher. So let's give you the refresher. It's a trust and a will both direct where your property goes when you pass away. The big difference here is a will, more often than not, if we're talking about larger assets, a will is going to have to go through probate court for those assets to get in the hands of the beneficiaries. And probate is not the end of the world, but for anybody here who's experienced it, it's not pleasant. It's very, very time consuming and incredibly expensive. There are, statutory fees that are just built into the probate code based on how many assets go through probate, and they really add up. And so what we do with a trust is we put those larger assets into the trust. And, what we do is help you identify what goes in the trust, what doesn't. We work with Jim to make sure those brokerage accounts are put where they need to be. We work with Mark to make sure all the tax issues are addressed. It's fairly comprehensive, but the basic purpose here is you put the properties in the trust so that when you pass away, they can be administered and dealt with in a way that's private, that does not involve any court oversight or supervision.
Got it. So is there a dollar threshold where one might face a probate?
There's a sense of a small estate in which you do not have to go through probate court. And that number is finally increasing a little bit, but it's just a shade over 166,000. Now, I should point out what that's talking about are assets that are just in your estate, meaning when you pass away, they have nowhere else to go. So that doesn't involve jointly owned accounts that you may have with your spouse. That doesn't involve accounts that have transfer on death, pay on death, beneficiary designations. So anything like that, the retirement accounts typically would have that, wouldn't be included here. The way I always describe it to my clients is, let's start with this. Do you own real property? And if the answer is yes, and most of us do, if you have at least a house, that's when you're going to need a trust, because there's no real concept of a small estate with real estate. The values here are where we live are significant enough that once you own real estate, you need a trust. There's a few circumstances where you could probably get away without it. And that's, as everyone said here, I'd echo it. It's very, very fact specific, and everybody's unique, and not everybody just gets a trust just because it's fun to have a trust. It's an investment, but for the most part, it's a necessary one for most of us.
Yeah. Well,
can I ask a question to Matthew on that?
Sure.
I've seen people put their children on their house title as a transfer mechanism or an unintended one. Can you address that generally?
Absolutely. I send them right back to you, Mark, because well, for the tax issue, that's a,
sure.
You can save on probate, but then you jump over into a potential a big tax loss. But just before Mark addresses the tax loss, one of the things I always say is to all of my clients, do you want to be asking your children for permission to do anything with your stuff? I mean, there's a time and a place where you would bring them in as a trustee, as an agent, somebody who's got a duty still to you. The distinction is it's still yours. They're just there to help versus, I don't want to go through court. I don't want to pay for a trust. So I'm just going to put my kids on title. Well, now you have joint owners, and not all of your decisions are yours anymore. You have to answer to the other people who own it. And so that's just a practical reason not to do it, but certainly losing, the step up with respect to the interest you give into the kids is a big no-no. So I'll let Mark address that one.
All right. Well, thank you. I wasn't even thinking of that when I asked the question, but yeah, I mean, correct me if I'm wrong, but if you put someone else on title, it's effectively a gift of half of the asset, which has a lot of tax implications, one of which is when you pass away, only your half gets stepped up, not the half that you gave to your child. Plus they own it now, and it's not part of the trust distribution. So it might totally wreck your plan if you expected that house to be divided into more than one hand. If you have multiple children, they're basically written out of the will and the trust on that asset, which might be your biggest asset.
Yeah, it's never something we recommend, and it's sometimes I've seen it happen. Sometimes people have come to me after the fact, and you'd be surprised. It's not always easy to get the property back into mom and dad's name, so it's one of those things. Those types of decisions really should be made after talking to people about the implications, because they're just too important to just do it because you think, hey, this will be easy and it'll all work out. It doesn't always work out, and so we try to plan around that.
And
so
what's
Mark, sorry.
Just a follow-up on that. What's the issue with bank accounts and investment accounts putting people on title or access to those? And what do you recommend people do to allow help, but not necessarily give away those assets?
Well, that's something we're seeing a lot of, where you have always one of the children. If there's one child, it's easy, we can address it and that's fine. When there's multiple children and you have one child who's kind of the caregiver, who happens to be the one put on the accounts because it's easy while mom or dad is alive. Well, when mom and dad passes away, the law says those accounts are now owned by that child. And as you said, that's typically not at all what mom or dad wanted. And you have this, just the stage is set for the fight. So if we're going to do that, there's ways we can put documentation in place to say that any persons who are added onto mom or dad's account, any children who are added on, are done only as a matter of convenience. This isn't, we're not trying to give them ownership when we pass away. There's ways we can address that so you can still have the best of both worlds. Right. But that's something that becomes a real problem. Now, sometimes people are fine with that, but you just have to be intentional about it, because once you start deviating from a pretty even split between the kids, inevitably they're coming back for the fight. And then what have we accomplished?
That's not our attorney, I assume.
So, and Matthew, you and I talked about this before, that so often I'm working with the adult children, and they have power of attorney, and they are adamant that that's all they need to sign all the legal documentation that I need to deal with in order to get the home sold. And I have to remind them that actually the trust trumps the power of attorney. So would you speak to that? Talk about power of attorneys. And there's a number of different types, by the way, and I don't think people realize that. And that when does that help? And when does it help? I don't even know if it helps when you're transferring property, to tell you the truth, if there's a trust, but maybe when there's a will. So powers of attorney is my question. Talk to us about that.
Absolutely. Well, power of attorney is going to be part of any estate plan. So if you have your binder that you received when you did your estate plan long ago, you'll have your trust, you'll have your will still. The will just doesn't do as much. It leaves everything basically to the trust. Then you're going to have your power of attorney for financial decisions. And this is for the things that are not in the trust. So as you said, Dayna, that's right. Anything that's in the trust, like the house, the big accounts that you've invested with Jim's help, those are trust assets. So the trust controls, and whoever the trustee is the one who gets to access them. The power of attorney is kind of for everything else. And the best example I give people is that's typically like your checking account, your day-to-day kind of activities, the stuff we do as people, not the trust, but what we just do as humans, paying bills, the day-to-day kind of stuff. That's where the power of attorney comes in play, because what's important is having that person appointed as an agent to act on your behalf is what keeps you out of court again. This time it's the same courthouse, but it's called conservatorship court. And we've been hearing a lot about conservatorships these days. That's just as bad as probate, because then again, you're under court supervision. We want to avoid that, and you can easily do it with the power of attorney, but it's an individual day-to-day decision. And just to round that out, you mentioned the different types.
Right.
There's really, most of the time we're going to give a broad power of attorney that's, pretty broad in scope, kind of a full scope power of attorney, not limiting it to certain activities. But within that, you'll see two types. One is what we call a springing power of attorney. And that's what most people have, which says, hey, I'm the boss until I can't be. And once I'm incapacitated, as determined, however the document says, 1 doctor, 2 doctors, committee, once that triggers, then it springs into effect, and now someone can act on your behalf. The other alternative, and one that becomes increasingly appealing as we get older or need more assistance, is you can make someone an agent immediately. And, you bring them on, and I liken that to be like a co-pilot. They're there, you're still in control, but you can just take your hands off if you want of the controls, and they can kind of step in and steer the plane a little, but you can jerk it right back because you're still the boss. So those are the two types of powers of attorney.
What's the second one called, Matthew?
An immediate power of attorney. But yeah, and Jim, go ahead, please.
Yeah, no, I was just going to tell a story, and it's actually of my own parents.
Perfect.
So my mom is 88. She's in skilled nursing. This is back in Syracuse, New York, where I grew up. My dad just celebrated his 95th birthday, and he's in independent living. And we did the second version of that, Matthew, where dad still likes to be in control, but there are times where it's too much for him anymore. He probably pays half of the bills. I pay the other half of the bills, particularly the skilled nursing bill, which he just can't look at. It breaks his heart. And it's a great way to be able to alleviate some of that burden and pressure from my dad. My mom's not capable of doing that any longer. So there are certain assets that she still has where I'm power of attorney. We hold all of our client accounts at Charles Schwab. So we go through Charles Schwab and their due diligence and compliance process to make sure it's all, all buttoned up. And I have 2 siblings, and they know what I'm doing, and I go out of my way to communicate that. So it is, Matthew, I think a really helpful way to be able to manage some of the, the day-to-day expenses. Like literally this afternoon, I got to help my dad with paying the property tax bill.
Mm-hmm.
And it's too confusing for him. He says he hasn't received one. I believe him, but I'm also not in Syracuse to be able to go through the mail with him. So lots of little things like that are great suggestions.
Awesome. Well, as long as I've got you on the stand, Jim, this question came up to me. So when a home is sold and the net proceeds from the sale just go into a bank account, is there anything we should be thinking about, concerned about, or planning for?
Well, I mean, that's where a lot of the financial planning work comes into play. Mm-hmm. Is now that the home is sold, and depending on where you're moving to, whether you're downsizing, whether you're moving into a senior community, what kind of cash flow do we need from that deposit, right? From the sale of the home relative to your other income. And back to Mark's original point on everybody's circumstance is unique, is that's where we like to harness the team together and sit down and now revisit the numbers, right? Revisit the financial plan to be able to say, okay, we really need this amount still growing. We need this amount doing something from an income perspective, and maybe in the process of preparing for that move, you've depleted some of your cash. And we're big believers in cash is an asset class. And what I mean by that is cash in the bank has a job to do, and that is to provide peace of mind. We go through this fun exercise that we call money barrels, which is we look at all the different assets that you have and we assign them to different time periods, which is as simply stated as now, soon, later, and never. And sometimes when you sell that never asset, the home, it's now going to get reapportioned across those other barrels. And that's where you want to, you want to sit down with your advisor and go through, where does it make sense to reallocate this money? Probably not just leaving all of it in the bank, although that might give ultimate peace of mind. Dayna, as you and I were talking the other day, I mean, in my opinion, inflation is really the dragon that we're trying to slay, and we need to have some of that money working for us in a prudent way.
Yeah. And man, am I noticing that at the grocery store, but we'll talk about that in a little bit. And Mark brought a good point up the other day when we were talking, which is that the reason we're talking about all this today is that people plan, you said this, Mark, for the worst case scenarios, and really don't always discuss just typical day-to-day scenarios. And most of us, and I love that you said this, I wrote it down, most of us don't look at our lives too closely or very often. And so this is giving us all an opportunity to do that, just to take a moment and think about some of these things. And that what you just said, Jim, is what the money's all about, what planning with a will and a trust, or having your taxes, minimized, is peace of mind. Peace of mind and not being fearful of your money. We're a lot of us that are here today are either retired or, well, we will retire at some point, or getting close to retirement, right? And so Jim's next question is the biggie. Jim, how do I not outlive my money?
It's one of the key questions that we get asked all the time. The concept in my world is this kind. I mean, we talk a lot about risk, right? We talk about market risk, we talk about inflation risk, we talk about all kinds of risk. And one of the big ones is longevity risk. And not to pick on my dad, but at 75, we couldn't believe he was still here due to a lot of health challenges that he was having. And here he is 20 years later. So that's where I don't mean to sound like a broken record, but that's where the planning comes in, where we can model these different scenarios. And with the cool software that is available today, we can plug in all of your specific information and run scenarios to show you what it looks like. And we go way out. We go to 100 years old. And most people we sit with are like, I'm not going to live to 100.
Exactly.
And okay, but what if you do?
So Jim, did you know that our first topic of the year was planning to live to be 100?
No, I didn't. But
I mean, that's how we
should.
started 2021 is planning to live to be 100. And we talked about the fact that whether you like it or not, you may be living to 100. And people tend to think, oh, well, my parents, they passed, or my grandparents, they passed away in their late 70s or mid 80s or whatever it was.
Yeah.
And more people are living well past what they thought they would. And so how are they going to live comfortably and have the lifestyle that they want and reach those dreams and goals, and enjoy their life, right? Enjoy their life. So
absolutely.
There's a lot of issues here that we were going to go over. Well, you touched about inflation. Is there anything else we need to talk about inflation? How do we can't avoid it, so how do we live with it?
Well, again, it's planning, right? It's looking at what sources of guaranteed income do you have today? Maybe you have, obviously, hopefully everybody has Social Security. Maybe some folks have pensions. Maybe they still have other kinds of rental income, and looking at what are the forms of their guaranteed lifetime income relative to their current expenses today, what we like to call their foundational expenses. So if you're still traveling and out and about having fun, which has obviously been very hard the last couple of years, that's a discretionary amount of money that we like to have a number on. And then you model out these different scenarios based on your assets, and hopefully not taking more risk than is really necessary. And to your point, Dana, the fastest growing segment of the population in the United States is 85 plus.
And
So, and no one ever expects to really need added care, whether it be in home or whether it be in a senior community. And the sticker shock for all of that is just extraordinary. So the old adage of, take your assets, or excuse me, take your age minus 100, and that's what you should have in equities. I mean, again, this goes back to everybody's situation is very unique. And that's where, thoughtful planning, with your estate attorney and your CPA and your financial advisor is really very, very important.
yeah. Well, we have a bunch of different issues we wanted to touch on, and I don't know who wants to take the RMD strategies and Roth conversion considerations and speak to us in English.
That's probably my arena. The thing that I find interesting is all of our arenas have overlap, and it's easy to step on toes, and I'll try not to, but there are implications with IRAs. I think sometimes we've touched on it. We don't coordinate it with our trust planning. And sometimes our IRAs, I've seen IRAs that are millions of dollars and are the biggest asset that my client has.
Mm-hmm.
And those are totally outside the trust. So there's that issue. What I like to do is I like to look at what someone's options are and can we improve those options. So in conjunction with that, I don't like, well, I shouldn't say I don't like it, but I often see people going all in on one strategy when there's things to be gained by having multiple strategies. And what I mean by that is I see people that are only in real estate. I see people that are only in munis. I see people that only have CDs, certificates of deposit. Some people are only in the stock market. And I think there's things you can gain as far as flexibility and options by expanding your horizons a little bit and talking to somebody that might be able to add comfort to going outside that one lane strategy. And with IRAs, there's various strategies. So with IRAs, you have two main types. You have traditional IRAs and you have Roth IRAs. And a Roth IRA is the other end of the spectrum. And what I've seen people do sometimes is they get overly aggressive and they do a complete conversion into Roths. And I don't advise that without adequate reasons. And most people would never have the reason to do that. And again, since it's so individualized, the main difference is if you're going to do a conversion, you're going to face taxation, and that's painful. But if you do it in smaller increments over a period of years, the pain can be minimized and the taxes can be reduced. So how you do it is as important as why you're doing it or if you decide to do it. And there's reasons not to do it. One example would be you have charitable ambitions. You want to leave some things to charities. Well, if you designate your IRA to a charity when you die, there's no tax implication. So you save that tax by not converting to a Roth. There's other strategies like that. You can also donate, from your IRAs if you're over a certain age, and that can be tax-free. You may have a year where you have big medical bills, and if you tap into your taxable IRA, you have a deduction that offsets that. So you save taxes by withdrawing in years when you have high deductions. So those are just some of the things to consider. And of course, it depends on the situation, but maybe you're healthy right now, but you know that you may not always be healthy. You may want to reserve some assets to protect you in the event that you need income in a year where you have those kind of deductions. So coordination is key, seeing the big picture and knowing that you don't want to be so focused on one strategy that you overlook the overall goal of what you can do with your portfolio. So
yeah, and to add, I love all of that, Mark. And to add to that, what we're seeing with some clients is occasionally there'll be these windows where their income is lower for a couple of years, whether it be before Social Security or even after, sometimes under the individual circumstance, they find themselves in a much lower tax bracket. And I think we are all pretty well trained to defer taking money from an IRA as long as we possibly can. And one of the blind spots that we like to kind of go through with clients is, well, maybe this is a good time at 68 or 74 because of your tax bracket situation to be able to pull some of that money out of the IRA because, I think, and we'll get there, I'm sure, with our conversation today, but, the 800-pound gorilla in the room is at some point, taxes have got to start to go up again. And so some thoughtful planning on that is really relative to required minimum distributions is really critical.
Well, yeah, that's true. And one thing I've actually seen and didn't think of it when I started was that I see a lot of zero tax returns, meaning they're not pulling money out of their IRA at zero tax rates when they could be. And if they have a one-time event where they have a huge medical expense,
sure,
and if the year ends before they take money out of their IRA, that opportunity is missed.
Yep.
And so knowing what your options could be is as important as where you might have your assets, and aligning deductions and income events is something that people can take advantage of if they know that they can.
Awesome.
We're really big advocates for clients doing some kind of year-end tax planning with their CPA, Mark,
yep,
so that they sit down, because more often than not, people just, they just by default, they go, we'll be fine. There's nothing we really need to do. Nothing was extraordinary. Or even if something was extraordinary, they don't think that there's anything that could or should be done. And we're always advocating that they sit down and do a tax projection or just have a conversation with their CPA around what their year was like.
Yeah, and the other thing that we see in those that are in the RMD arena, which is required minimum distributions, is that they just go on autopilot and that's all they'll take out without considering maybe they should be taking more out. And that's an overlooked opportunity that I think is, 90% of the people that are taking RMDs probably are on autopilot. And that probably shouldn't be.
Oh, that's an interesting point. I'm going to keep us moving forward, guys, because it's, I want to stay, I'm looking at the clock here, but we've got a ton of things to cover. So I have a topic next year that is entitled Going from We to Me, meaning we lose a spouse, we lose our loved one. But what is the tax impact of losing a spouse, Mark? And then you mentioned 1-year planning opportunities. Talk to us about that.
Well, depending on when a spouse dies, you have that year to file a joint tax return. And because the tax laws are different for singles versus a joint return, it may be a good year to do some strategizing and do some taxable events, such as selling the house. It's got a stepped up basis. There's going to be no gain tax. So that might be a year to consider selling if it makes sense. Of course, you don't want to just do it for that reason. Again, you have to have the big picture view. Other things is that, there might be opportunities to do things with IRAs, as we just talked about. But the following year, you're going to file as a single person, and your tax brackets are half as big as they were the year that you lost your spouse. So again, deciding if there's anything to do. Now, we're sort of talking about properties generally. One mistake I've seen people make is that maybe they don't pay the taxes that they could in the year of the sale. They wait till the next year. Sometimes that's a good move, and sometimes it's not. You miss an opportunity for a tax deduction. And those deductions have been limited the last 3 years, but the current administration is trying to change that back so that there's more tax advantages to paying state taxes in a year. So that's another thing I didn't mention before, but ties into taxes.
Well, and so we're on the subject. You mentioned capital gains, tax ramifications when selling a home, obviously, when you've lived there many years. we had Prop 19. Do you want to just kind of remind us about Prop 19?
Yeah, sure.
You had mentioned an installment sale perhaps, or, anything else to avoid the taxes. I mean, I brought up the 1031 exchange, which takes a ton of planning.
Right.
I
All
see
those
very
would take a
few-
seminar, but let me briefly try to hit some of those. And the 1 year, so if you have a stepped up in basis, you don't really need the exclusion anymore. So that sort of goes away, but certainly if you're going to sell some rental properties, that's a good year to do that. You would no longer need to do a 1031 because there's no gain to defer. Everything gets reset to current value and you can start depreciating again. So that's a tax issue. Prop 19, that changed the property transfers. In order to keep a low property tax assessment, the person that is receiving the property has to, one, be your descendant, generally your child, and two, they have to live in it as their primary residence. So that's a big change. Some of the good changes is that now you have the flexibility to move up to 3 times and keep your low property tax base. And that's even if you end up buying a more expensive home, which I see a lot of people do actually. It seems counterintuitive, but we see it happening. So you can keep your low property tax base and you can move anywhere within California. And that begs the question, a lot of people that come to me say, hey, I want to move to a cheaper state. The reality is there may not be a cheaper state. It depends on where you fit on the scale. I've done analysis for people that want to move somewhere else and it's more expensive there. They don't realize it because maybe they don't have an income tax, or maybe the things they don't think about is Social Security is not taxed in California, but it is taxed in some other states. You have higher property taxes in other states. They don't have Prop 13. So if their house goes up in value, they end up paying more tax. There's things that are good about our state. And sometimes it just doesn't make sense to move out of state. And they're doing it only for the tax reasons. And that's very dangerous thinking, is to do things only for the tax consequence.
Yeah.
Or the perceived one.
So, gosh, we've got so much to cover. Matthew.
Dayna, if I can add one thing to the,
Yes.
When one spouse passes away, I'd want to reiterate that it's really important to, again, talk to all of us about what's going on. I've seen a lot of surviving spouses who kind of just put their head in the sand, and, time passes and some of these opportunities are lost. And I think what we also find is a lot of the trusts were drafted in a way that made things very difficult when one spouse passed away. And it comes as a big shock and surprise to a lot of people, but there's often a lot of administration that has to be done right away when one spouse passes away, even in a nuclear family situation, even we don't have stepchildren and things like that. And so we just want to always be mindful of, hopefully it's not the case. Hopefully there's not much that needs to be done. And it's just a quick, everything looks good. We'll kind of help you transition here and there. Maybe we should rethink about who's going to be your successor trustees, because, long ago you appointed your spouse. Well, you've lost your spouse. And as Jim said earlier, maybe that kid's moved out of state and, it no longer kind of works. But there's just that is a time, as hard as it is, as difficult as it is, that you do need to be mindful of, these things and talking to us, because the problems don't go away. And if you're not going to deal with it, then we find ourselves in court a lot to have to clean up things that would have been really easy to take care of at the time. But, years and years go by, and these things eventually are going to rear their head. Yeah.
And I'm going to go off topic a minute, because we did talk about this together, which was, when's a good time, and this is for you, Matthew, when's a good time for the adult children to have access to parents' documentations? And where should we keep remember, we're in the age of technology now, everyone. So now we've got logins and passwords for all these online accounts and portals, and probably a lot of people have their money strewn all over the place. So when should that documentation be accessible to the adult children, or or if you don't have any children, where do you keep that where it's safe, and that whatever you've said in your will or trust, it's in there somehow. I don't know. Tell us about that.
It's something we address. I mean, there's important legal pieces of these documents, and then there's just some real practical things that we need to deal with. And that's one of them. So most of, anytime we're putting together an estate plan, there's a section in there that has instructions, important information for whoever is going to be stepping into that role. Now, I like the idea of making folks aware, whether they're the adult children or others, that, hey, look, I've appointed you to be my successor trustee. Most of the time you're asking them if they're okay with that anyway, but reminding people that they have this role and then sending them some of the documents is great. I don't love sending the trust to the kid. I think it's okay in a lot of situations, but remember, you reserve the right to change your mind the rest of your life. And so anytime expectations get set, and those expectations are later unmet, you have a big problem on your hands. But more often than not, I think parents get pretty comfortable. No, I'm gonna, here, I'm gonna give everything to my kids. They can see it all and know how it all works. It's all even, and that's okay. But with respect to accounts and passwords, we set these binders up in a way, these portfolios, to be conspicuous. I mean, you don't want to have this hidden away because the originals matter. Someone's going to need to walk in and find your trust, find your will, find your power of attorney, find the wet ink signature. And so I don't like putting passwords and sensitive financial information in that. But what I do is I like to have in places where people can kind of refer elsewhere and say, look, list of passwords is in the safe deposit box at Wells Fargo at this branch, and just kind of helping direct people. Important information I keep in this desk drawer. And I mean, often families know, but it's very fact specific, but anything you can do to make someone's job easier, it really does go a long way.
Awesome. Mark, you wanted to add something.
Yeah, I think you need to involve the children the year before you really need to. And we don't know when that is really, but I think sooner's better than later. That's something my dad used to always say, sooner's better than later. I have a lot of children come in after their parents pass on, and they don't know if their parents have been filing tax returns. They don't know when the last one was. We have to do research to try to figure out if they're current. We also find a lot of problems with the quality of the self-prepared tax returns. I think from just maybe from a review perspective, involve your children as early as you are comfortable doing it, but don't put it off forever, because I think they can be a real help in avoiding costly mistakes down the road and clean up headaches. I mean, it sort of depends on what do you want to leave your family members. Do you want to leave them a mess, or do you want to leave them something that's not a big burden? And I've seen both, but I see the burden more than I see everything's really straightforward and easy. So do what you can to involve everybody.
Jim?
And one thing to just add to both of what you guys have been sharing, which I couldn't agree more with. My older brother, unexpectedly passed away in 2012. And he was divorced. He was a do-it-yourselfer on his estate planning, on his tax returns, and everything was e-statement. We had no passwords. We had no idea where anything was. And as unenvironmentally friendly as this may sound, I'm not a big fan of e-statements, particularly if someone is single or widowed. Because there's no way to know, unless you can get into their email. There's no way to know if it's coming to their email where that money is. And I love the idea of a spreadsheet of usernames and passwords in the safe or the safety deposit box or somewhere secure, so that in the event that something does happen, like Mark is saying, your kids and loved ones aren't really dealing with a mess, because it took us years to clean up my brother's situation, that with some conversation and some planning would have been really helpful.
And don't forget to give your family and loved ones the the safe combination.
Oh, yeah.
Absolutely.
I mean, call me crazy, but and then I guess let's wrap up with gifts versus waiting for trust to distribute property. Is that a good, can we have a good answer for that? Who wants to take that?
I mean,
Well,
I'll
go ahead,
start it
Jim.
and kind of ping pong with everybody, but I mean,
Okay.
that's where we've got a number of those situations right now with clients where we're looking at planning to know, is traditional gifting of $15,000 per spouse to as many people as you want, is that sufficient, or should there be, while all the limits are higher, should there be a more aggressive gifting strategy relative to property, right? Whether it's real estate or other assets. So I'll
Yeah,
kind of tee it up with you guys on that.
I'll just focus on some mistakes, and that's gifting right before someone's about to pass away, asset that has a very low tax basis. When it's going to get a stepped up basis if it stays in the estate. I've seen people do that with houses and businesses where they've decided to gift it instead of have it inherited. And a lot of times there's no reason for it. There's no need to do it. It's just they feel anxious and they get panicky and they say, oh, we got to take care of this now. Maybe they think it's going to be easier to do that. But what they do is they hand their child a huge tax obligation if they ever sell it. And so, there's times it makes sense and there's times it doesn't. And I think just revisiting these things again, just paying attention a little bit, sitting down and going over this with advisors, I think is key to success, and optimizing all the things that you've been able to accomplish in your estate. You don't want to give it to the government if you don't have to.
Right. Right. Well, that's a perfect way to end, because now we're going to dig into some questions. So folks, if you have any questions, just go down to the bottom, that little Q&A, and click on it and you can type something in there. So I've got a question. Please address question of estate tax exemption portability. That sounds like that's coming from a fellow professional maybe, but I don't know.
I don't know. Is that mine? I don't know.
I don't know. Who's talking about taxes?
I mean, it's both of ours, isn't it, Mark?
Yeah.
I mean,
We bring it up all the time, but.
Well, we take advantage of, back historically, there was a very low estate tax exemption. It was 600,000. It went up to $1 million. And now we're in, since, the 2010 forward phase, it was 5,000 adjusted up, and it doubled effectively. It's going to sunset back down, but we're in a stratosphere right now. And Jim just mentioned it. There's some planning opportunities because the exemption amounts, what you can pass either through lifetime gifts or when you pass away, it's all the same bucket. There's a lot of money you can transfer without any estate tax, any gift tax. So what we do is we take advantage of the fact that, well, in most cases, if people are well comfortably under those limits and we're not expecting them to come down to where they're going to really start affecting people, because there's this thing called portability, we can make it easy where you can leave everything to your spouse and keep things simple. And what you'll do there is realize that the spouse will be able to inherit your half of everything, and then they can take your unused exemption. That's what portability is. So we all have our exemption. Right now it's like 11.7 million. Whatever it is at the time, you're taking it and you're putting it over so that when your spouse passes away, they have theirs plus what they received from you. And portability allows us to, keep a plan on the simpler side, if that's what folks want, knowing that even if the estate tax, drops down a little bit, the limits, there's still some extra cushion there. So it gives us more options. That's kind of the thing we talk about when we're designing a plan with a married couple. There's a lot of options there, but I hope that wasn't too esoteric, but that's kind of what this portability concept's all about.
Okay.
Well,
Another question.
Can I address that a little?
Oh, yep. I'm looking at the time. Yeah, go for it. Go for it.
So there's a 2-year window to pick that option. It also, if you have an AB trust, there's a newer mechanism that you can do, I think, disclaimer trust, to do what Matt was talking about. and I'll let you go to the next question.
There's so much.
There
I know,
is.
Mark, there's so much, and you guys are all so knowledgeable about all this, and you do work very well together. Let's see, one person said, I thought IRAs were beneficiary contingent and therefore not included in trusts. Please clarify.
That's correct.
That is correct. And not maybe that question goes to a point I made in the beginning about sometimes as a named beneficiary, you will see a trust as a named beneficiary on the IRA. But relative to that question, that is correct. They are beneficiary contingent, not included in the trust. But where it gets really messy is if the trust becomes the beneficiary of the IRA. We could have a whole talk on that.
Mhm.
I have to think about that. Okay, okay. Let's see, another question is, if you want to review your trust, taxes, etc., as a senior, who do you see? She says all of the speakers.
All of us.
And then she says, in other words, how do you put this all together to make sure you're in good shape? Like who would we talk to first? And I guess I would say you do definitely, like my husband and I don't make any major financial decisions unless we talk to our attorney, CPA, and financial advisor, and they all bless it. And sometimes they literally all get on emails going back and forth. So who would she see?
Yeah, I mean, I think very, very simply, it's where do you think the situation is, right? Where does the pain lie? If it's been a long time since you've done anything in terms of reviewing your trust, I'd start with Matthew. If you're contemplating selling a house or an asset and there's a complicated tax thing, I'd probably start with Mark. And if you're worried about outliving your assets or the way your portfolio's currently performing, that's probably where you'd start with me. So I mean, I hate to say it depends, but I think I think taking some action and starting with one of us would be great.
Perfect. That's perfect. All right. Another question. And then, does appraisal on death of spouse give stepped up value more than the year of death?
Well, the stepped up basis is based on the appraisal. I'm not sure I understand the question, but
Yeah.
it's the date of death that establishes the value. It's whatever it was worth that day. So the appraisal should be backdated if they're done later.
And I want to ask you a question, Mark, because I just had yet another CPA call me yesterday asking me to do a date of death appraisal. I am not an appraiser, and there is an IRS code that states that realtors should not be doing that. And why am I the only realtor that follows that? Or am I?
You're not the only one that does it. So to take a position, you generally have to make a reasonable estimate, and an appraiser is going to have a better estimate maybe than yourself, but it's not to say that it wouldn't work. I don't know any case law on that particularly, so I can't say that it's going to work for sure in every case, but we see them a lot, and sometimes that's the best somebody can come up with given the circumstances. I would pay the money for an appraisal. That's just what I recommend.
And I always
there's an IRS regulation. You're right, Dayna. I mean, it's supposed to be an appraiser, a certified appraiser in California Bureau of Real Estate Appraisers. Like, they have a list. You can go to the county.
Thank you.
But I will push it off to Mark and say, hey, I'm not filing your return. So if your CPA is comfortable taking that position based on, on the facts and circumstances, some other mechanism to establish value, because that's what's going to get reported to the IRS. I mean, talk to your CPA about it, but that's the safe way to do it. And when you're a trustee and you have a fiduciary duty to all the beneficiaries when you're dealing with this, just follow the letter of the law. Don't cut corners to save a few $100. It's just not worth it.
I don't like shortcuts.
Pay the money.
Right. I mean, and a realtor can give an opinion of value.
Oh yeah.
And I will give them what I think their home would sell for. in today's market, which could be a different number.
There's actually different appraisals. You have to specify that it's for this purpose in the appraisal, which makes me think that it's very specific what they want. So yeah, I mean, do it right. Make sure your appraiser knows that you're appraising it for the IRS.
Right.
Not just because you're curious or you're refinancing. You want to make sure it's going to hold up in a review. And
Right.
Yeah, and
Okay.
most appraisers know and understand that now we're not in the estate tax world where we're used to want low appraisals. Now we want a high appraisal. We want the basis stepped up for income tax. So if you go to sell it, no capital gains. I mean, so they kind of get what we're trying to accomplish. You're not, I mean, they're still going to be reasonable, though it is what it is, but they know, you know, that's what we're trying to accomplish here. That's pretty much a given these days.
Right. I've got a couple more questions we can cover, but I want to make sure Jim is okay. Do you need to leave,
Okay.
Jim? Okay,
Yep,
okay.
I'm good.
Okay, a couple quick other questions. Let's see. Okay, and these are getting a little specific here, but you know, life is like we keep saying, everyone's situation is unique. So we have got a couple that their names are on the title of their son's home in Georgia. His name is on title as well. How does this couple remove their names without tax complications?
Well, it's you got to speak to someone in Georgia. I mean, my license stops at the border here, so it would have to be some sort of quit claim deed or some deed done under the super. In some states require an attorney to be involved, some don't. Like Jim's home state in New York does, for instance. It's complicated transferring real estate, but you know, you talk to, you'd want to get their names off title, and you talk to your CPA about, you know, what sort of gift tax informational kind of return you need to file to show that there was this substantial gift. I mean, depending on the value of the property. So taking the name off isn't that difficult. Typically, it's just a deed. You know, someone can transfer a gift deed. We do it often. Then there's some follow-up work that, you know, someone like Mark would be helping you with. So
it's done about 10% of the time.
Got it.
Yeah.
Okay.
Right.
And
Right.
we're gonna take the very last question, and then we'll wrap up for the day. Jim needs to go. So I want to buy out my siblings' shares of my father's home when he passes. His estate is not sufficiently large for the house to just be left to me as my portion of his heritage. I plan to live in the house. What hoops do I have to jump through to keep the full Prop 13 tax rate?
Okay, that's still being settled. I mean, under the old Prop 58 before Prop 19, there was some really great, you know, State Board of Equalization regulations that we could follow, and the trustee would get third-party loan, and you would equalize, and there's a way it's done. I would just say, from a planning perspective, the best thing you could do is, you know, if this is all kind of in discussion with mom and dad, you know, talk to them about maybe putting in the trust that you have an option to purchase the property, and then the assessor, you know, really the State Board of Equalization, but the county assessor is going to look at that as you have a claim to 100% of it. So it's less looking like you're buying out, because there's a parent-child transfer, but there's never a sibling-to-sibling transfer. There never has been. And that's the rub, you know, are you buying out? Are you getting it from mom and dad, or are you taking it from your sibling? So that's, I think, probably something you would, you know, you'd want them to discuss with their estate planning attorney. What should they be doing in their trust?
Well, I can't thank you enough. Jim, Matthew, Mark, wonderful information. We're so lucky we have people like you to handle this kind of stuff and help us avoid disaster by planning. I think that was the main topic, right? Pre-planning to avoid disaster. And I think you gave us a lot of really good solutions and things to be thinking about and to do. So with that, thank you very much. Hopefully we'll see you maybe back next year. And I just will say goodbye. And I can't believe I'm saying this. It's December 1st. Happy holidays to all the attendees today. Yeah. Unbelievable. So we'll see you all next year. God bless you all. Be healthy, safe, happy, and have a wonderful holiday season. And thank you again, you guys.
Thanks,
Have a
Dana.
great day.
Appreciate it, everybody.
Bye.
Bye.